Great and wide powers are conferred for the governance by great sovereign countries, and such powers cannot be withheld on IHC ground that they may be used externally or oppressively. Settled principles of construction and interpreting constitutions preclude limiting the language of the Constitution by political, juristic, or social concepts in DCPCN, dently of the language of the Constitution to be interpreted, 406-47 DTP Chandvarang, Stadt of Uttar Pradesh, 1959, Supi 2 SCR 8, Kwun Vabura, 1887, 5 Aya, on 79, 11 Ornti Gitientral for Ontario, Viatorni Gitientral for Canada, 1912 AC, 571, Gopalan CM, 1950, SCR 88, Kuhan Madaminan v State of Bombay, 1951, J, SCR 228, and B. Mawari Lal Sharm Case, 72, IA 57, RCFCF RCD 2. All provisions 0 are the Constitution are essential and no distinction can IGEM. DC between essential and non-essential features from the point of view of amendment unless the makers of Constitution make it expressly clear in the Constitution itself. The theory of implied and inherent limitation cannot be allowed to act as a boa constrictor to the clear and unambiguous power of amendment. When certain restrictions are imposed in Article 368, it is not in. Problems of the country will show that no provision can be considered non-essential. The character of the provisions which are amendable under the Rovesk to Article 368 itself shows that the petitioner's submission that Sesson Sal features arc unamcanable is a baseless vision to find out essential or non-essential features is an exercise in IR ponderables. If there are no indication in the Constitution as to what the essential features are, the task of amend MCent of the Constitution becomes an unpredictable and indeterminate task. There must be an objective standard by which it can be predicted as to what is essential and what is not. See Senial. If Parliament cannot judge these features, Parliament cannot amend the Constitution. P-bar, Party 7, Party 8, Party 9, Party 10. There is no foundation for the analogy that just as Jusix test reason, Abiel CNCS is in law. The judicial mind will find out the essential features on the test of reasonableness. Reasonableness in law is treated as an objective criterion. Supreme Kawit Repopts, 1973, Sup SCJL. Scouse reason inheres in man as rational being. The crucial point I1 that, in contradistinction to the American Constitution where rights are couched in Wick J, when Article 368 speaks of changes in the provisions of the Constitution as ARC set out in EOS A to D of the proviso, it is manifest that the makers of the Constitution expressed their intention with unerring accuracy that FCA lures which can broadly be described as federal features, and from that point of view essential features could be amended. The proviso confers that power with relation to the judiciary, executive, and the legislature, none of which could be said to be non-essential. The contention about unamendability of essential features do not take into consideration that the extent and character of any change in the provisions of the Constitution is to be determined by legislatures as amending bodies under Article 368 and as representatives of the people in a democracy, and it is not the function of the courts to make any such determination. P4 Manurong, 412. Kesavananda Bharati, EFJ, 25 a higher source, and which can and ought to be regarded as invalid when it comes in conflict with higher law. It cannot possibly include a law which is self-validating and which is never invalid. The distinction, constituent and legislative power, is brought out by the feature in a R1G1D Constitution that the amendment is by a different procedure than that by which ordinary law may be altered. The amending power is therefore said to be a recreation of THC Constituent Assembly every time Parliament amends the Constitution in accordance with Article 368.64, 365-374 View Contra in Golaknath Ferd, State of Punjab, 1967, 2 SCR 672, held in Correct Macaulay v. King, 1920, AC 691, and Bribery Commissioner v. Pedrick Ramuingi, 1965, AC 172, held inapplicable. Article 368 in the unamended form contains power as well J, as self-executing procedures which, if followed by the P-ascribed authorities, would result in an 11 amendment of the Constitution. The power to amend meant the F-Jower to adulter or reprol any provision of the Constitution. The power is unlimited so long d. The realt is an amended Constitution, that is to say, an organic insterflernant which one vidies for the making, interpretation, and